Good morning. I'm here today to tell you my executive summary for my legal research project that I've been conducting, looking at the current vilification and anti-hate crime laws that are current within Australia at the moment, and to see whether or not these laws actually fulfill their purpose or do they need to be reformed in some way to bring the legal system up to date with public opinion and perception of how these offences should be dealt with. I will be looking at, in particular, how, if there is a reform, how this would affect the number of crimes being reported, that the written consent of the Crown's officer would no longer be required. If the burden of proof was made slightly lower, it would be easier to obtain a criminal conviction, and this would allow for the protection of more minority groups who come under these particular laws particularly, and enable better reporting and prosecution of such crimes. It would also improve relations between the legal profession, the police, and these minority groups who suffer vilification and hate crimes. On the other hand, the current legislation does already allow for reporting of such crimes, and it's up to the police to find that they can a case to put together that would be admissible in court. To remove this from to remove the freedom of speech and thought in such a way that no one could disagree with someone else may be counterproductive. The purpose of law reform isn't to take away the rights of anyone else and give them to someone else, and it's about balancing between the two groups. And it could potentially lead to some people being arrested and found guilty of a criminal offence when they were really not aware that they were committing a crime, if it's at the lower end. And this could have long-term implications for the rest of their life to have this kind of a conviction on their record. And often you find younger people might participate in activities like this when they're not fully aware of the consequences. There's no guarantee that even if the law was reformed, that it would lead to any more prosecutions and convictions, and would that in turn actually change the amount of incidents that are taking place. It could, if it was seen not to be working, then it could lead to a worsening of relations between police and the victim groups, and it could, escalate further in that regards as well. The legislation we'll be looking at is the Anti-Discrimination Act of Queensland from 1991, the Racial Discrimination Act 1975 Commonwealth, the Criminal Code Act 1995, and the Human Rights Act of 2019 in Queensland. The relevant case law to look at will be the Australian Broadcasting Corporation and O'Neill from 2006, where the court held that the full court did not give enough weight to the significance of free speech in considering the prior restraint of a publication, and also Monis and the Queen and Wotan and the Queen, that's 2013-2015, where the court considered the implied freedom of political communications through the postal service and found that this freedom wasn't an individual right, but that it still couldn't use the postal service to send hateful mail to particular groups of people that was unsolicited. and look at the implications of how could legal reform change these offences taking place. In conclusion, although there are relevant laws that are available today that can and are used by the police to prosecute, but unfortunately the successful prosecutions are very small. There is therefore an argument that legal reform could help widen that scope, where more can be done to help people who are suffering from these hate crimes, and help not just the victims, but those who commit the crimes. This legal reform can help prevent these crimes being taking place in the first place by making them a slightly more stricter and easier to prosecute, where a known outcome could be quite detrimental to anyone who did choose to participate in these activities. And I will be arguing that there is a need for some kind of legal reform in this regard. Thank you.